data protection law will be relevant where there is a processing of personal data. In other words, whenever there's a processing of information relating to a person. In conducting internal investigations, it's very likely that personal data will be processed. It's very important to be aware of the obligations under data protection law and to apply them to the various activities under the investigation. So, for example, gathering data for review, which could include witness statements, compiling investigation reports and other records, sharing data or work products during the investigation, making reports to regulatory or investigating authorities, and also dealing with data sublet access requests. So those involved with the investigation should be aware of the obligations under data protection law and apply them to the personal data processed as part of the investigation. They should seek advice if they're not sure, and the organisation could consider updating training to relevant staff if necessary. A key area is in relation to satisfying the transparency requirements under the legislation, and this is often the most challenging of the requirements to satisfy in practice. In the context of an investigation, of particular importance will be informing the relevant individuals whose personal data are to be processed of the purposes of the processing and with whom their data may be shared. This is typically done in a privacy notice or privacy policy. There are some exceptions to this, however they are construed narrowly, and knowing what exemptions are available and when they can be applied will be very important. Organisations should consider whether there are appropriate privacy policies in place for those individuals that may be relevant to an investigation in the future, including employees and agency workers, and if so, whether they cover the ways in which data may need to be processed for the investigation.
GDPR sets out 7 key principles, and these principles lie at the heart of the data protection requirements. So you must process personal data in a way that's lawful, fair and transparent. It must be collected and processed for a specific and legitimate purpose. It must be relevant and limited to what's really necessary to meet that purpose. And the data must be accurate and kept up to date and not kept for longer than is really necessary for that purpose. And it's important to maintain the security of the data and also to be able to demonstrate your compliance with GDPR. So in conducting the investigation, you'll need to identify valid grounds under GDPR, a lawful basis for collecting and using any personal data. And you must do that before you begin processing the data, and ideally document that. So make sure the personal data that you gather and review is really necessary and proportionate. Think about date limitations, search terms, phased approaches where you can demonstrate that one phase informs the next, and avoid phishing expeditions. And lastly, think about how you will safeguard the security of the data in how it's processed and shared during the investigation. So there are 6 available lawful bases for processing personal data. And the most likely bases that you will consider in the context of an internal investigation are firstly consent. So is it possible or appropriate to seek consent from the individual for processing their personal data for the specific purpose of the investigation? This might not always be appropriate. Requesting consent may not always be viable. It may prejudice the ability of the company and in due course the authorities to conduct an investigation into the matter. Is the company under a legal obligation? So is the processing necessary for the company to comply with a legal obligation? It may be possible to say this applies if you're required to process the data for regulatory requirements, for example. Or legitimate interests. This is probably the most usual ground which is considered in the context of an internal investigation. So is the processing necessary for the company's legitimate interests, or is there a good reason to protect the individual's data which overrides those legitimate interests? So this effectively requires a balancing assessment. Why does the company need to process the data? What is the legitimate interest? And is it necessary to use that personal data to do so? Or can the company reasonably achieve its purpose by some other less intrusive means. And then the balancing test. You need to consider the individual's interests and whether these override the company's legitimate interests. And where you will be processing special category or criminal offence data, you will also need to determine whether any of the relevant conditions apply.
Data subject access requests, or DSARs, are a common feature of investigations. They're typically raised by someone involved in the investigation to find out how the business as data controller has been processing information about them. And they're a particularly useful tactic in any collateral HR dispute that might come out of the process. This is because under GDPR, the data subject has a very broad right of access to their personal data, with only a few limited exceptions that allow for the withholding of information. So how do you handle these? Well, as with many aspects of data protection compliance and in the investigation space, good preparation is key. This goes back to the way the investigation has been set up and how the investigation materials are being treated. How and where is data being stored? Who has access to it across the corporate group? And is it or can it be maintained under a cloak of legal privilege? You'll also want to ensure that you have a robust DSAR response procedure in place so that data can be easily located. You'll need a team that understands the regime and is able to coordinate a response, getting advice where necessary on what data, if any, can be withheld. Another key point that can be missed is for how long after the investigation the materials are going to be retained. GDPR requires organisations to have appropriate retention and data deletion policies in place, and there can be a real benefit, both in terms of data privacy compliance and also managing litigation risk, in not retaining investigation materials for longer than is strictly necessary. This, of course, needs to be balanced against the organisation's need for the materials for any future purpose, and also any potential regulatory considerations.